hold while you're being connected. Gracias por llamar a McCullough Reamer Lieber Pierce. Este es un intento de cobro de una deuda y toda información obtenida será utilizada por este propósito. Manténgase en la línea mientras conectamos la llamada. Please hold while I try to connect you.
Hello, this is Will.
Hey, Will, how you doing? This is Jonathan.
Oh, hi, Mr. Presley.
Yes,
Okay, if I call you.
excuse
Is
me?
it okay if I call you John?
Yes, yeah. So,
Okay,
okay, excuse me, but did you have time to pull the prospectus?
To do what now?
Did you have time to view the information that I faxed to you or emailed to you?
Yeah, I've been looking at it all, but I'll be honest, I don't quite follow it. I have a lot of questions for you, if you don't mind being patient with me. I don't quite follow what it is you think that this law firm can do for you at this point.
No, it's not that. The thing is that your law firm had your law firm never had the title to the your law firm was representing a different trust. You with me?
Okay, who is the one we were representing?
You were representing a trust company called HSI Assets Securitization Trust Company.
Okay, and who was it that we thought that we were representing?
That's who you were representing.
Okay, and you said it was wrong, so who's the right one?
The trust that held the title to my property is New Century Trust Holding Inc.
Okay.
Okay? But the documentations that were filed to procure the deed of power is fraudulent because the deed of power on the foreclosure document has HSI Assets Securitization. That's the deed of power that they used to foreclose on me. But it was New Century Trust Holding Inc. that conveyed the marketable title to the property that is the collateral, along with the lender's title policy. Basically,
Okay, and
that the documents.
So this was a property that this law firm conducted a foreclosure on?
Yes, sir.
What is the address of that?
2369 Temple Johnson Road. If you check it, yeah, I'm listening.
Well, what year was that?
It was the date was November the 4th, 2014.
And have you ever been in the property since then?
No, because at that point you outsourced an eviction notice. But no, they forced me out.
Okay, please go on, please.
Yes, they forced me out. Your law firm outsourced a company called Prime Funding Inc. Okay. Now, Prime Funding Inc. is a real estate company. All right. From that point on, McCullough Reamer outsourced a law firm to file and facilitate the documentations that was necessary to gain possession of my property. But at this point, when your law firm conducted that foreclosure, it could not produce a marketable title or a chain of title documentation. I also have the lender's title policy. I also have the chain of title documentation.
Okay.
So the thing is, the deed under power is fabricated.
Okay, so let me ask you a question, more basic question.
That's
Did
why,
you pay the loan?
no, if you did, I mentioned New Century Mortgage Corporation declaration,
Mm-hmm.
disclosure statement. I also mentioned the federal bankruptcy court up there. I also gave you a case number, 07-10416. On one of those copies, images that I had an attachments to, you will see an image that says New Century Trust Holding Inc. and Jonathan Lee Husky Documentations Production. In other words, McCullough and Raymer and the opposing party never even had the documents.
Okay.
Now, basically, in 2000, and one more thing before you leave.
I'm not leaving. You got me for as long as you want me. I just wanted to help try to make the picture clear here. And one thing that I'll say is, even if everything you say is true about what happened, it does not get you your home back, and it doesn't matter if you did not pay the loan.
The thing is, we have two different trusts that's claiming the same. Yes, it is, especially when the Delaware Bankruptcy Court, listen to me, transferred the title, New Century Liquidating Trustee, Alan M. Jacobs, transferred the title or conveyed the title to the property that is located at 2369 Temple Johnson Road, Snellville, Georgia, to me. That's me. Okay? Now, we all know in Georgia, the one that has the title and also the chain of documents is the owner. Okay? That's the Georgia, that's point blank. I have the title. And I had a title even when you foreclosed on me in 2014, November.
Did you give the property as collateral for a loan?
If you read the disclosure statement on page 112 and 113, I thought you had this information with you. You will notice that the note and instruments of the collateral is canceled. That's why I was conveyed not only the documentation, the lender's title policy, the chain of title documentation, and along with an invitation from KCC, which is Alan M. Jacobs, trustee, claims and noticing agent. You heard that voicemail. Look.
I did.
Okay, I filed my claim. Okay.
So I'm trying to understand a really basic idea here. Okay, so be patient with me, please. On this property, when you owned it, did you get a loan on the property?
Yes, I did, and I'm anxious.
Okay, and did you pay back that loan?
No, you know why? The loan and the note and the instruments were canceled.
Okay, so let me let you know where the law is, right? Looking at this is the really big picture.
Oh yeah.
Everything that has to do with loan documents being transferred between lenders, assignments, where the loan was or wasn't in which trust. All of that, if there are mistakes, that side is between the lenders. Okay, that's who has those claims. That only you're not a party to those contracts.
I'm listening.
You don't have any standing to argue about what lenders do between themselves.
I'm listening.
Because it doesn't affect you. But what a court will tell you in Georgia is they'll ask the exact same questions I have, which is, did you get a loan? Did you pay it back?
But
And if the answer is no, none of the rest of it matters.
you know what? Yeah, yes it does.
You don't
Listen.
you don't get free property and you don't get free loan money.
Listen. That's what. Listen. I'm trying to tell you. I'm sending you everything. Look at the information that I'm sending you. Okay. And this what we're talking about is really confidential. All right. But the thing is, every borrower, you said borrower, when it comes to New Century Mortgage Corporation, when it comes to that Chapter 13 or Chapter 11 that was filed in 2007, okay, when that hit bankruptcy, you got to understand your bankruptcy law, okay? Every single assets of New Century Mortgage Corporation, aka the operating debtor, aka the mortgage originator, aka each and every asset, okay, is on lockdown, which means it's locked in the Delaware court until actions and lawsuits. Here's the thing. It's all about the mortgage loan repurchasing agreement. That's why the documents are held in the Delaware Bankruptcy Court. Alan M. Jacobs is the trustee that FedEx everything I'm telling you to me at the address of 2369 Temple Johnson Road, Snellville, Georgia. 2369 Temple Johnson Road. And another thing while I got you on the phone, we talking about a foreclosure that was completed by your law firm in 2014.
Mm-hmm.
There was another foreclosure completed by another law firm in 2013. And I'm not gonna, you can look in your files.
On the same property?
On the same property, on the same note, on the same security deed, and with the same mortgage identification number. Okay? The opposing party and a legal representative, there's a difference between that 2013 foreclosure and this 2014 foreclosure. The party that you sold this mortgage to is called Prime Funding, Inc., which is headquartered in Florida. They are the straw buyers. When you sold or auctioned this mortgage off to Prime Funding, Inc., you did not even have the title to the property. Your company conveyed a limited warranty deed. Now, like I said, you mentioned borrower earlier, you mentioned loan earlier, but there's two things that you and I both know. That whoever, it could be a mortgage company, a financial institution, a mortgage originator, but the first thing they will do is buy a title insurance policy.
Okay.
To protect their interests. Like I said, I have the lender's title policy. The second thing they have to do, they purchase fire and hazard insurance property. Fire and hazard insurance to protect their collateral. Now here's the thing.
But usually that will require the borrower to do that.
Yeah, but see, it all depends. I had a choice, okay, to do that, purchase it myself, or I can have that built into my payment.
Mm-hmm.
Okay, now, you feel I want you to remember the name, New Century Mortgage Corporation, New Century Financial Corporation, New Century Trust Holding Inc., New Century Liquidating Trustee, New Century Restructuring Plan. Point is, the point is, the trustee that you're representing never had a documentation or the legal standing or any interest in the property. It was all a fraud. And I got the proof. Okay?
Okay, so
Like I said, but here it is. But the main...
question.
Okay, yes, sir.
I need to clarify something at this point. Okay, when you say fraud means something specific.
I know what it is.
Usually fraud means, just let me play this out, please. Fraud means somebody did something on purpose to hurt you. Do you think that's what happened, or that it's possible that there was some kind of accident where something didn't get recorded the way it was supposed to?
No,
Because an accident isn't fraud. Like, for fraud, somebody has to mean to hurt you specifically. Do you think it's that one or the other way?
I think the whole thing was premeditated. Okay? I think that I know I can prove that the whole thing was premeditated. Okay? It's a Chapter 11. Okay? The operating debtor is also New Century Mortgage Corporation. It is, and also, New Century has two assets, my friend. It has the originating assets, the lending assets, and also it has the servicing assets. Okay? April 2nd, 07-10419. Okay? We talking about the New Century Servicing Platform and Carrington. Okay? Also, I've been tracking you ever since Flynn and Howell. That's how long this been going on. You just came into the picture.
Yes, sir. I have the job that Thomas Howell used to.
Right. Okay. Now Thomas Howell, I know he's a blonde-headed guy. He looked like a Q-tip. He went to the University of Georgia. Now I'm trying to tell you, I know him. That's how long that's been going on. And Flynn. Your friend Flynn even he filed a protection order on me in 2000, back in 2000.
I'm aware of that.
And I cannot understand why he done that.
Well, it's probably because if you were doing what you did in the last 2 days, that comes off as harassment. I'm not saying that's what you meant to do, but whenever somebody calls that many times in a row or sends that many emails in a row and talks about some of the things you were talking about, it could be intimidating or harassing to someone.
Hey, check this out. But here's the thing. He had an opportunity to make his appearance in 2011, but he chose to file a motion of removal. From that point on, he ran. He had an opportunity to end this thing in 2011, but he filed a motion of removal. And here we are today.
Well,
here's the thing. You and I both know that the documents that are filed in that Gwinnett County Courthouse are unchecked. They are not verified. Number two, you and I both know that this is a non-judicial foreclosure state. Okay? Number three, you and I both know that I have the legal right to challenge, which I did in 2011, but you and your partners filed a motion of removal. That case has yet to be litigated. It has yet to be adjudicated. We have not went to trial yet. Okay? But yet, here we are talking about the lead case. But here it is. The thing is,
Sir, we can't have a conversation if you keep interrupting me.
All right, okay. All right. Go ahead.
It's too difficult. Thank you. Thank you. I really appreciate you listening to me on that. Just to be clear, and again, you correct me on anything that you want to, but removal simply means that they take the case from state to federal court.
I know it.
That's all it means.
I know.
The case. What happened when it went to federal court?
You know what? Look. What happened when it went to federal court? When it went to federal court, I had a legal representative, Alex Rupesky. You probably know him. He was my attorney.
Is that an attorney?
He was my attorney. Here's the thing. It went to federal court. He failed to notify me that it was dismissed without prejudice.
Okay.
That case was dismissed without prejudice. From that point on, I lost him.
Okay.
You see what I'm saying? And he reappeared in 2014 to help facilitate that writ of possession that was used to evict me. You got to understand, a 2013 foreclosure was already been completed. He never told me that. The thing is, it's a non-judicial foreclosure state. The documents that are filed, anybody can file documentations if they have the courage to. Because none of the documents are verified. Okay? Now, as a citizen...
When you say verified, do you mean documents like recorded in the public record or documents in a case?
In both. In a public records of office where the land and title to the property are filed. Okay.
In that context, verified doesn't mean anything to me.
But the thing is, but here's the thing. I had the title to the property when you foreclosed on me in 2014.
That makes sense.
And I watched you do so. Okay. I had the title to the property in 2011, but your party and your colleagues filed motion of removal. The thing is, that information would have been known then, but before we even got to a hearing to have a trial, the opposing party, Thomas and Flynn, filed motion of removal. The thing is, information, this case would have been over in 2011 based on the fact that I had the title to the property then. From that point on, it was all about conspiracy. It was all about a pattern of deception. That's what this is all about. And then you still cannot produce a marketable title to the property. Why? Because I have it. The thing is,
so marketable title is not something. That marketable title is not something an attorney or a lender has to produce in order to do a foreclosure. That's what a seller has to produce to a buyer.
But the thing is, yes.
The marketable title. That phrase doesn't mean anything in this context.
I also listen. I also have the warranty deed with it. Now we all know that the warranty deed transferred the title to the property. I don't care if it's a security deed or a mortgage or a trust deed or a trust deed. That's the law. The one that can produce the warranty deed and the title to the property, and the one if the title says and the warranty deed says you are the mortgage, you are the grantee with my name behind it, associated with it, with a stamp and a sign and a seal, and with the federal title insurance company sign of approval, and with New Century stamp right there on top of it. I am the owner of the property, which is located at 2369 Temple Judson Road, Snellville, Georgia. I have that
Okay.
information and everything with it. And also, the servicer could not do anything because you had two mortgagees. Okay? In 2011, well, during the federal court, they had a problem. They filed motion of removal because you had two mortgagees, two lenders, okay? A conflict of interest, a cloud, and a title. The technique that your partner used is called the cutout technique. 2000, that's why that foreclosure in 2013 was all about. I know you have the information when you transferred the servicing and when you transferred the whole entire case to another foreclosure company. Do you have that information in front of you?
Sorry, say what? Say again, information?
In 2013, there was another foreclosure company associated with this mortgage that we're talking about. Do you have that information?
I'm sure I have it somewhere. You sent me a lot of stuff, but
No, I didn't see that.
Okay, well this brings up a good point. I'll tell you, you sent me a lot of emails that just have something in the subject line, but there's nothing attached to any of them. A couple of them have some pictures attached, but I just want to make sure you know that some of them, if you meant it to be like that, that's fine, but some of the things you sent me, it seems like you meant to attach documents to them, but there's nothing on them. It will just be like a subject line and then nothing.
Well, that's a user error. Okay.
Okay.
But here.
Okay, that's no problem.
But the thing is, while you're on the phone, all you have to do, man, will turn to your computer, man, and just Google New Century Trust Holding Inc. And I know there has to be some type of documentation that has Jonathan Husky and New Century Trust Holding Inc. in front of you. Right?
I don't. I'm talking to you. I've got.
I mean, you don't see that information.
I'd have to go and look for it, sir. I mean, this
well, that's what you need to look
I'm
for.
not giving you.
Oh, I'm sorry. Hey, you know what? I think we just made contact. Yesterday? Was it?
Mm-hmm.
You probably haven't had time to go over really the emails and stuff. I know you probably there now looking through the things, but there is a document.
Can you explain to me what difference it makes?
The difference is the different. Well, it's called residential mortgage racketeering. Okay, you didn't have standing to do anything.
Okay, so racketeering.
I know what it is, and listen.
References criminal activity. What is the criminal activity here?
Look, David. I'm not a lawyer, but I'm right. But look, check this out. On the Georgia racketeering statute, you qualify. Put it that way. You look it up.
I'll tell you, I do have some experience with this, and I can tell you, I have gotten many RICO claims by borrowers dismissed because it is not a claim borrowers can be successful with against a lender in Georgia. I've never seen it happen.
I know. So, it's always the first time, but the thing is, I'm trying to contact you, and also because I told you I didn't want to get in that class action lawsuit that went down in 2011. Okay, because she had I'll call her Albany. She had you against the rope. She was right. When Colin Raymer manipulated and used to their advantage the whole non-judicial system to gain or take property from individuals. And the only difference between me and every one of those other
cases that you litigated on, I have proof of ownership. I know where it come from. I know how I got it. I know why I got it. And I know that David Brad Maurice, the CEO, got caught up on some charges that caused this whole, that involves me. That's why we are talking today. But the thing is, it's the pattern. I am able to show a pattern. It's the pattern that we're talking about of deceptions that leads to conspiracy. Okay? And the only way that you and your law firm could gain access to my property with me holding the title to it is by filing fraudulent documentations in that courthouse.
Okay, let me stop right there. So, whenever, and I'm going to speak generally now, and let me see if we understand the same thing, okay? So, let me play this out, and you tell me if you understand this to be correct or not. So, out in the world, just hypothetically, anybody, not you, not this case, but what happens when you get a loan is you're usually buying property at the same time, so let's take that for granted. Person buying takes a loan and takes title to the property at the same time, and when they take title, they give a security deed to the bank that says, you know, if I don't pay my loan, then you can foreclose the property. And that gets recorded usually right behind the warranty deed in the public records, because usually it's all happening at the same time. Now, what has happened at that point is the borrower has title, but the bank also has an interest in that title as collateral for their loan.
I'm with you.
Now, if the borrower does not pay their loan, then a foreclosure might happen. And at the point where a foreclosure happens, the borrower still has title to their property, but at the foreclosure sale, title transfers to the buyer at the foreclosure sale.
That's the point I'm trying to get to you, Will. They didn't have the title to transfer at the foreclosure sale.
Okay, some lender did though, because you got a loan and you got money.
But David, I'm sorry, but Will, here's the thing. You keep talking about loan. You keep talking about lender. But yet, don't forget who the lender used to be or was. Don't forget who originated this morning. You have.
Okay, well let me use my example.
I listen to you. Let me finish. The lender is New Century Mortgage Corporation. The lender, okay? I'm gonna repeat that. The lender is New Century Mortgage Corporation. Okay. Now, the lender is also known as the operating debtor. Okay. The lender is also known as the mortgagee. Okay. The mortgagee is also known in this case as the debtor in possession. Okay. New Century Mortgage Corporation is the debtor in possession. You don't understand? What we are talking about was in federal court. And at the same time, you don't understand, when this information was in the hands of Flynn and Howell, in my case, I was in Delaware arguing my case, 07-1041. It's because the documents that are filed in Georgia or in any non-judicial foreclosure state is unchecked. You can do anything here, but we are going by the prospectus. That's what this is about. If you have your if you get that prospectus of HSI
Asset Securitization Corporation. Pull it. It's public information. Then we'll talk. You can't you cannot understand because it's your job. Here's the thing.
Well,
You didn't have actions or standing to do what you did. You did. Even the mortgage servicer didn't even have actions to initiate this foreclosure. The mortgage servicer, the mortgagee, did not even have the actions to even call you to take this case on. Period. I can prove it. Which
Okay.
mortgagee has the ability or the authority to call you to initiate this foreclosure? In 2013, which mortgagee has the authority to call McCullough and Raymer to initiate this foreclosure? You didn't have the authority to do so.
is that a question to me?
It's a question and also a statement and maybe a comment. The point is, the mortgagee did not have actions or the rights to even call your company to initiate this foreclosure. Bottom line. You see what I'm saying? You can't do it. Your servicer didn't even have the right to do that. The mortgage servicer, the mortgagee, is the one to pick up the phone and call MRLP and take this case on. They didn't even have the rights to do that. To initiate this foreclosure, the mortgagee has to call you. Okay? Period. Which mortgagee called you? Which mortgagee called David Howell and Mike Flynn to initiate this foreclosure in 2011? Period. You got the information? It's the mortgagee, Will. That's the one that has to call you. Period. That's the law. In order for you to get involved, the mortgagee has to call you to initiate the foreclosure.
Just to clarify, anybody that who's holding the loan designates to call us can, or they can email, or it can come through a computer system. There's lots of ways for these things to happen.
Somebody has to initiate foreclosure. Someone call you to initiate the foreclosure. Period.
Okay.
So the person whoever made that call for you didn't even have the rights to. See, you shouldn't even be involved in this because the person who called you lied. Put it that way. Bottom line.
And you think they can set up?
I can prove, I can prove that the person that called you to initiate this foreclosure in 2014 didn't even have the right to. That's how you got involved. You cannot you cannot get your law firm cannot get involved until the servicer initiate this foreclosure.
Do you think they did that on purpose?
I'm just gonna leave it right there. You know, just as well I know, the servicer has to call you to get involved. The thing is, which servicer was it? How else will you get involved in this case, Will? What'd you do?
That sounds right.
You just go
right.
You just go
I'm
right there.
telling you.
You just go out there, knock on doors, and then say, "Hey."
That is of course correct. Our clients contact us to give us referrals.
Okay.
That's how the system works.
Exactly.
However,
No.
there's
Okay.
nothing that you have told me so far that makes me change my understanding of the facts, which are you have not paid back a loan and so you were foreclosed.
No, you don't understand, and you fail to educate yourself on the subject matter. You just picked this thing up.
Well, I have been doing this. I have been doing this a long time.
No, but yeah, I'm sure you sound and you're well educated and well spoken. Okay, and I know you probably get your suits tailor made. But the thing is, I own the property. Okay, and the thing is, in order for you and this company to get involved, someone has to call you. Someone has to initiate the foreclosure, and the person that called you didn't even have the right to call you. So basically, you got to get your. So what, sir?
What difference does it make as to whether or not you actually pay back your loan?
Look, it's not the point is, man. The point is, the mortgage originator got caught up in some stuff in mortgage insecurity deed. Number 2, plain and simple, it's public information, and I am involved in this courthouse up there in Delaware. The thing is, he got caught up in security frauds, mortgage-backed security frauds, okay? Here's the thing. New Century borrowed money to make money. All the mortgage loans that New Century originated, they borrowed from other institutions. Then, when the interest rate went out of control, that triggers early default payments. Bam. When the early default payments come in, then you talk about repurchasing obligation. The documents were never transferred to Dutch Bank National Trust. The documents were never transferred. Period. I have them. New Century never transferred the documents to the sponsor. Okay? Therefore, you shouldn't have been called. You see what I'm saying? Because this is not your case. The service should never have even had called you to initiate this foreclosure. Remember this. The mortgagee should never even call you to initiate this foreclosure. Okay? You should never been involved in the first place. The servicer did not even have the right to call you. I can prove that. You have the information. We talked about it. You heard it. All I have to do is press play. You hear it for yourself. Carrington. You heard it for yourself on your voicemail, Will. Okay? You heard it on your voicemail. Carrington purchased the servicing rights. Okay? You heard that. You also heard that your client, SPS, Select Portfolio Services, and Carrington don't know each other. Okay? Now, I gave it out. Which mortgagee has the right to call you to initiate this foreclosure? Which lender? Now we're talking about a cloud in the title. The thing is, Will, the servicer did not even have the right to call you, your company, to initiate this foreclosure. Because the servicing platform was sold to Carrington Mortgage Services.
Okay, well, let's start from there then. Let's take that as true. Let's assume that is true. I don't know that it is. I'm not saying that it is, but so that you and I can continue our discussion, let's assume that what I'll say is let's assume whoever sent the loan to this law firm for foreclosure didn't actually have the right to do so. Now, from there, what is it that you think this law firm can do at this point for you?
I can't believe you're saying this. Will. Okay, now add fraudulent foreclosure to your scenario today. Okay?
Okay, and your point is what makes
now add because you just said, what if they did not have the right to do this? But we are talking about a foreclosure that was completed in 2013 and 2014. two foreclosures on the same property with the same mortgage identification number, you know, from the same mortgage servicer. You know,
And then back it up.
you know what I mean?
What you want me to assume is that whoever sent it here did so with knowledge that they couldn't and wanting to hurt you.
Wait a minute. Listen, no, let's back up. And let's focus on this right here, what we're talking about. The mortgagee,
Well, that's fraud.
the servicer, did not have the legal
But that
authority
could be,
to
that
call
could be just
you.
an accident.
Listen, man, listen what I'm saying. The mortgagee and mortgage servicer did not even have the authority to call MRLP to initiate this foreclosure.
And I'm telling you that in a situation like that, there are a million ways why that could be fixed, why it might just be an error, why it does not matter for you.
No, but the thing is, it should matter for you and your law firm. That's what I'm saying. Because
Well, it's done. It's done and litigated.
No, because I'm trying to tell you, there's a case number that was filed in 2000 that has yet to be litigated
They got dismissed.
without prejudice.
Okay. Are you going to refile that case?
Why do you think I'm calling you? Wait a minute. Why do you? Wait a minute. Hold on. Why do you think I'm calling you? After all this time, why do you think I'm calling you?
Well, it sounds like it's
Wow.
you're telling me you're going to file a case.
We just wasting time. That's why the case in 2000 it has yet to be litigated. Okay. I mean, it was when it went to federal court, it was dismissed, but without prejudice. That case had yet to be litigated. Okay. That's the one that Flynn and was that guy who hit me with a what do you call it, restriction whatever his name is. Good shot, by the way, anyway. But anyway, you did not have the right. He could not. You could even set foot in Gwinnett County Courthouse then, not without committing perjury. Period. Why? Because of the mortgagee. The mortgagee did not have the authority to even call you to initiate this foreclosure. That's why you filed a motion of removal. Like I said, you would have known, you would have saw the title in my hand if your boys would made that appearance. I wasn't going to show you everything. But the point is, you didn't have standing. You know, it's a strategy that you use. You have strategies and you have teams. This team, foreclosure team, you should see that on your email. That team made mistakes. Okay? Flynn and Howell made many mistakes in 2011. From that point on, I've been documenting everything. Okay? I even know who the opposing party, mortgagees. More than one. I'm not going to tell you who they are. But the thing is, one of those mortgagees had a conflict of interest. Neither one of them had the right to initiate that foreclosure. The mortgagee did not have the right to call you to initiate, to get you even involved in this. That's and that could be proven. And that would have been proven in 2011 if the opposing party, your buddy, had not filed notice of removal. You're right. It went to federal court, but it was dismissed without prejudice. Right now. That case has yet to be adjudicated. We didn't even have a chance to have a hearing about a trial. Because they took off running. They never set foot inside that courthouse. I took them to the federal courthouse building. They never showed up. Like I said, even then, your boss had an opportunity to, I even had an opportunity. But it wasn't about getting him in the federal court. It was about getting also Select Portfolio Service in there too. And then you had Trustee Goodman. And then you had Carrington was there too. But the thing is, the servicer did not even have the right or the authority to call MRLP to even get involved in this, to initiate this foreclosure. You had to be called by someone to get you involved. Let's go back in 2011 and tell me which one was it. But anyway, I think, well, I guess, like I said, I guess to answer your question about that case in 2011, and I'm going to refile it again, but I can because I have the right to, because it's my right to as a citizen.
Okay, well, if and when you decide to refile, I'd appreciate it if you let me know.
All right, man. You have a blessed day, you hear?
Okay, I'm happy to talk to you again whenever you like. If I can pick up the call, I will.
Okay. I'll send you an email.
Okay.
All right.
Bye-bye.
Bye. Point is, I got him. The servicer mortgagee never even had the right to even get these people involved. Period. Wow.
Metro Capital. Back 40 years ago when you were a doctor with a dinky web page and some inheritance money, we've all done very well. Why don't you just stick to stock? Look, you told me I look for value wherever it can be found. And the fact is that these mortgage-backed securities are filled with extremely risky subprime adjustable rate loans. And when the majority of the adjustable rates kick in 07, they will begin to fail. And if they fail above 15%, the whole bond is worthless. Michael, just take a beat. We'll talk about this later. Lawrence, please don't patronize me. This
Mortgage-backed securities, subprime loans, tranches. It's pretty confusing, right? Does it make you feel bored or stupid? Well, it's supposed to. Wall Street loves to use confusing terms to make you think only they can do what they do. Or even better, for you just to leave them the fuck alone. So, here's Margot Robbie in a bubble bath to explain.
Basically, Lois Rainieri's mortgage funds were amazingly profitable for the big banks. They made billions and billions on their 2% fee they got for selling into these funds. But then they started running out of mortgages to put in them. After all, there are only so many homes and so many people with good enough jobs to buy them, right? So the banks started filling these bonds with riskier and riskier mortgages. Thank you, Benjamin. That way, they can keep that profit machine churning, right? By the way, these risky mortgages are called subprime. So whenever you hear subprime, think shit. Our friend Michael Burry found out that these mortgage funds that were supposedly 65% AAA were actually just mostly full of shit. So now he's going to short the bonds, which means pathetic gains. Got it? Okay. Now fuck off.
It's only a matter of private for someone else's thesis investment. We have that. How do you know the bonds are worthless? Aren't they filled with fucking thousands of pages of mortgages? I read them. You read them? I read, yeah. No one reads them. Only the lawyers who put them together read them. I don't think they even know what they've paid. The housing market is propped up on these bad loans. It's a time bomb. I don't want to short it. Through what instrument, Michael? There are no insurance contracts or options for mortgage bonds. The bonds are too stable. Lawrence, this is what I'm going to do. I am going to get a bank to make me one. Then I'm going to buy it.
I don't want that kind of business. Money is not money. That's bad money. Hey, excuse me. Let me ask you this. What company treats its customers that shittily and succeeds? Fine. Okay, Goldman. You're right.
Mark Baum had built his career on never assuming anyone or any company was legit without proving it. When he was a kid, he excelled at studying the Talmud and Yeshiva. Whatever. But one day his rabbi told his mom why.
Paul is a fine boy. Mark is an excellent student of the Torah and Talmud.
Then what's the problem, Rabbi?
It's the reason Mark is studying so hard. He's looking for the inconsistencies in the Word of God.
So has he found any?
Later, Baum started his own fund on Wall Street. He had an amazing nose for bullshit, and he wasn't afraid to let anyone know when and where the bull had gone number 2. Then a tragedy happened to Mark, and it turned his whole worldview dark and ready to believe the whole system was a lie.
Hold on. It's Cynthia. I'll be in the office.